Do you know for a fact that CPR had not been given?
I do not know for a fact.
And do you know for a fact that CPR had been given? So you stated earlier that the type of weapon that was found was a .45 caliber?
Yes, ma'am.
Is that a semi-automatic?
It is.
Okay. How is that different from like a revolver? What's the difference between that?
Oh boy, call mom returning to the courtroom today for her conspiracy to commit murder trial. Our legal eagles are grading lawyer Lori. Plus, we're addressing the many objections that Lori drew and the few that she's made so far. Plus, also this hour, we're talking about accused killer Bryan Kohberger. He's back in court today for a major motions hearing. The biggest question, perhaps, will those Amazon searches be suppressed? Plus, Dr. Ingolf Tuerk returns for cross-examination this morning. We're spotlighting his very emotional testimony. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm your host, Julie Grant. Are you ready for some coffee and some court, as I like to say? Let's get it going. We got a great show planned. Grab your coffee or tea or whatever you like in the morning. It's time for my opening statement. Cult mom doesn't know when to come in and out of the rain. If you watched her crossing the witnesses on Tuesday, you know what I'm talking about. All she did was waste everybody's time. I don't even think that she knew why she was asking half of the questions she asked you. She was just crossing to cross. Cult mom, I have a free trial tip for you. If you don't have a purpose for your question, don't ask it. Sit down. My friends, my favorite dumb question of the day was when she asked the detective to explain the difference between a revolver and a semi-automatic firearm. It's like asking a grocer to explain the difference between an apple and an orange. They're not the same. Both are fruit, both are guns, but you really can't mistake one for the other. You know, the whole performance Tuesday makes me so mad for Charles Vallow and for everybody who loved him. Because the way I see the evidence, that generous, loving man was set up. He was set up and he was lured into that house where lethal trouble would find him. I am sure never in a million years did he think that his brother-in-law would shoot him to death. May Charles Vallow get justice. May his name and his loving legacy be always remembered. And may all of us forget about Cult Mom after her trial. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
I had really high hopes that things would work out. I snapped, I kind of blacked out.
What did you do?
I grabbed her.
Where?
On the neck.
How?
In Massachusetts, defendant Ingolf Tuerk returns to the witness stand today. Going to be crossed some more. Court's going to start up at 9 a.m. Eastern, and we will go in there live together when it does. In Idaho, we've got accused killer Bryan Kohberger back in court for a major motions hearing. It's going to start up today at 11 a.m. Eastern time. And in Michigan, we've got the defense case continuing in the murder retrial of Linda Sturmer. Court's going to get underway at 9 a.m. in that one. Now, let's turn to our top story. Counselor Cult Mom returning to the courtroom as her own defense attorney. Tuesday, she cross-examined first responders and law enforcement witnesses. One key question during a fire captain's testimony was, did Charles Vallow receive CPR prior to a medic arriving on scene? Let's take a listen to how she handled that.
Had adequate CPR been given there, I would have expected more blood, possibly on there, and perhaps a pool of blood under him.
In this case, Captain Keller, do you know for a fact that CPR had not been given?
I do not know for a fact.
And do you know for a fact that CPR had been given?
I know for a fact that we gave CPR.
Prior to your coming in?
What was your favorite question of the day or moment of the day? Hit us up on social media. Let us know. 1:30 p.m. It's going to start back up. There's that 30-minute delay imposed by the judge. So we, of course, abide by the court's order, and we will show it to you as soon as we're allowed. So let's talk about lawyer Lori. Yesterday, we graded her, and it worked out so well. We're going to do it again today. I've got two great guests standing by. Let me welcome them. And now both of them former prosecutors, currently criminal defense attorneys, Franz Borghardt and Ryan Tuerk. Good morning to you both. All right, time to grade lawyer Lori based on yesterday, Tuesday's performance. Franz, would you start us off?
I'm going to give it a D-. In terms of, look, this is like watching a bad romance where someone who's in love with themselves is literally just, serenading themselves to no end. These questions sound flowery and nice, but there's no substance to them. And it's kind of like when you watch a TV show where someone's trying to be a lawyer and it's comedic because they're asking like Perry Mason questions that really aren't there. It's D- for failure. I mean, but kudos to her. It's not an F today. So,
yeah.
I mean, there you go.
There's that, Franz. Yeah, she showed up. She showed up to court. Oh, Ryan Tuerk, what would you give her?
Good morning, Julie. Look, just say this, D-, you still pass, right? And so that's all she needs to do. All she needs to do is pass. And look at, we've seen worse, Julie. You and I have worked in the same courthouse, and I've seen worse. So I'm sure you have too.
No, right.
So
You say that.
Look, a prosecutor's worst nightmare is to go up against a pro se defendant and lose, right? So, I'm sure the prosecutor, even though this may be an abysmal performance, they're probably still thinking in the back of their mind, oh, what if I lose, right? So, there is that element. There is that element. I mean, it's maybe getting to the head of the prosecutor. Who knows?
Yeah,
but,
you're right about that, Ryan.
It's a serious case, and I've seen defendants, especially in the most recent era. I've seen a lot of defendants, both state court and federal court, sort of trying to take the reins of their own defense. I mean, it's an interesting phenomenon that's occurring right now, but I'm seeing more and more of this type of representation. I wouldn't advise it. I think that it's obviously not advisable, but we are seeing it for some reason.
Right. As Abraham Lincoln famously said, he who represents himself is a fool for a client. And Ryan, I love the point you made because it's really true. And I've been a prosecutor. I admit it. I've had that fear before. Franz, I mean, harken back to your time as a prosecutor when you maybe get a pro se defendant. And I'm sure there are people in your office who are going, oh, don't lose this one, right? There is that legit fear, isn't there?
So, yes, there is the legit fear of I don't want to lose to this defendant, this pro se defendant. But let's not lose sight of the fact that everybody in this case is playing with house money. How many life sentences is she already serving? There's no scenario where Lori walks out the back of the courtroom exonerated and goes home. She is doing life in prison. And look, she just can't help herself. So to me, the prosecutor puts on their case. They've got strong evidence. Let her make a mockery. Let her make a circus out of the courtroom and just bide your time because the conviction is coming. And so, yeah, she just can't help herself, and it's going to get worse, especially when the hard evidence of her guilt comes in. So, to me, it's more of a don't drop the ball scenario. I don't think it's not that she's going to outmaneuver lawyer or out personality. Her narcissism is not going to win them over with charm. So I think it's more of a don't drop the ball.
Sure. Franz, I love what you said about how everybody's playing with house money. I mean, she really is. You're right. She's rolling the dice. What does she have to lose at this point? Gets her out of jail being in the courtroom here, so there's that. I have a clip for you both, and I referenced this moment in my opening statement because for me, it was the moment yesterday. There were quite a few where I'm scratching my head, but I threw my hands up and it was like, I can't with her and the pointless crossing. She asked the question to a detective to explain the difference between a semi-automatic handgun and a revolver. Let's watch.
So you stated earlier that the weapon, the type of weapon that was found was a 45 caliber?
Yes, ma'am.
Is that a semi-automatic?
It is.
Okay. How is that different from like a revolver? What's the difference between that?
The build itself, I like to use simplistic terms when I describe what a revolver looks like. Most people are familiar with a Western movie. So the wheel gun, that's a revolver. What you see modern police officers carrying these days are semi-autos.
Good night. Ryan Tuerk, let me go back to you. So much of yesterday with her reminded me of that scene in Billy Madison where he does the debate and the principals says how terrible it was, and it's like, I award you no points and may God have mercy on your soul. That's how bad I felt like it was. Ryan, help her out. What tips would you give to Cult Mom here, please?
I guess the one thing I could say is, sort of know the answer or generally know the answer to the question before you ask it. You don't want to ask a question that you don't know the answer to and then, be slammed with an answer that you weren't expecting or something that just works against you. That's just the worst feeling, an amateur mistake. That's probably the best piece of advice I could give her. Actually, the best piece of advice would be to lean on her standby counsel and allow her or him to take over at this point. That's probably the best advice I would give. The second best is sort of know the answer to the question before you ask it.
Right. No, excellent advice, Ryan. Excellent. Franz, tell me, what advice would you give Cult Mom?
So I actually don't come down as hard on her for the gun question, only because as a prosecutor, sometimes when I'm educating the jury, I will ask questions that are like, wait, that's an obvious, because not everybody in the room knows the difference between semi-automatic and so I'm not going to give her a D- on that. But what I will say is this. Stop trying to be a TV lawyer. And if you're going to defend yourself, get to the meat and potatoes. Juries don't like having their time wasted. They're already in a place that they don't want to be in. So stop wasting their time. Get to the meat and potatoes of what you're really getting after. A good defense attorney through cross-examination can do that. She can do that. But it's stop with the pageantry. This is not a beauty pageant. You're not trying to flirt with jurors. Just get to it. Stop wasting time.
And she was in the beauty pageant. She was in the Mrs. Texas pageant. She was stunning. I don't know what happened. I don't know what happened to this woman. Her family doesn't know what happened to her. Ryan Tuerk, tell me, crazier things have happened, with juries. I mean, we never know what a jury is going to do here. We know she wasn't in the house at the time. We know her brother did the shooting. We know there is some evidence linking her. There are messages and such. And of course, we know what happened in the other trial in Idaho, all three of those convictions. But do you think that, could it be possible that Cult Mom is victorious here or it at least gets a hung jury?
You don't know until the jury is done deliberating. You know that as well, Julie, as you just said. Nobody knows what a jury is going to do. The prosecution appears to have a strong case, but they may feel some sort of sympathy. So it's hard to answer that question. However, it does appear as though she will not prevail in this case. As Franz said, this is a strong case against her. However, you don't know what one juror, all it takes is one juror to disagree with the government, to disagree with their evidence, and to hold out or, possibly cause the other people to hold out to the point where everybody says, look, not guilty. Stranger things have happened. I had a homicide trial that I tried twice, both on hung juries, and, one person held out because they followed the instructions, to a T, and to that person's credit, they followed the instructions, which in my particular circumstance, in my case, the defendant chose not to testify, which is their absolute right. And, after the jury hung and they were dismissed, we spoke to the jurors, and, the one juror who held out said, look, 11 people wanted him to testify. And I kept saying to them, it's not his obligation to testify. Wow. He has no obligation to do so, and you can't consider that, which was why they held out for 4 days. So look, strange things can happen. You never know. the likelihood is probably against her being acquitted. I would agree with Franz completely on that point, but you just never know.
You're right. And Ryan, thank you for telling that story, because it's something we talk about almost with every trial here on Court TV. We say, look, it's the defendant's right, as you explained, to not testify. It can't be held against them. But the natural inclination of people, right, and jurors, the people, is you want to hear the story. You want to hear their side of things. So, wow. Great, for you and your client that you got that holdout there. My goodness. Here's what we're going to do. We're going to keep talking about Cult Mom a little later in our show. Ryan, Franz, I combined you guys' names. This is terrible. Ryan and Franz, stand by, please. We're going to hit our first break. When we come back, here's what's coming up on Opening Statements.
Do you recall seeing any projectiles on the ground near the victim?
Objection, leading.
The yes or no question.
I believe I did, yes.
Oh, we're going to analyze all the objections that Cult Mom drew and the ones that she made so far in her trial. Plus, there's a big motions hearing happening today for accused Idaho murders defendant Bryan Kohberger. His team wants his Amazon searches suppressed. Will it happen? That's next.
Daybell,
already convicted for the murders of her children.
Doomsday Cult Mom is now lawyer Lori.
she's representing herself.
On charges of conspiring to murder her fourth husband.
She said, I can murder you now.
She really thinks she's equipped to try this case.
She appears very sure of herself.
I have real trial experience.
It's going to be a strange trial. We'll see how it plays out.
The Cult Mom Conspiracy Trial. Live coverage today, only on Court TV.
Welcome back, and now for what's trending in true crime. Idaho accused student murders case killer Bryan Kohberger is set to be back in court today, as a judge will determine what evidence can be included and what will be excluded in his upcoming August trial. The judge has to consider more than 170 filings that could have serious implications. All these what are called motions in limine, the motions ahead of time. The defense team wants to block digital data from Kohberger's Amazon account. Prosecutors alleging that he bought a K-bar knife along with a knife sheath to match months before the murders. They say he bought it from Amazon. Prosecutors also say that his touch DNA was found on the snap of the sheath that was left behind at the crime scene.
And the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
Good point, Judge. The defense also wants to block the testimony of an Idaho State Police crime lab manager about the ways in which so-called touch DNA can wind up on an item. So this morning, we're asking our power panel, how likely is it that the defense will get this evidence tossed out? Let's bring back in Ryan Tuerk and Franz Borghardt, and welcome in criminology expert and author and Professor Dr. Debbie Goodman. Great to have you all here on this case. And I'm going to start with our lawyers on the panel and then get into what the alleged motive is in this case. So Ryan Tuerk, if you would start us off, the Amazon searches that he bought the knife with the sheath prior to and then after the fact that he was searching on his computer for a replacement. Ryan, how likely do you think it is that the judge will keep this out?
I think, Julie, it would be good for the defense, but I think it's a low likelihood. I think considering the circumstances surrounding this case, the type of weapon that was used, I think that it's going to be a long shot for them, for the defense to be able to have their motion in limine granted that would actually keep that out. I think that that's strong circumstantial evidence, and I think the prosecutor will make a very good argument to overcome the motion that was filed by the defense in this case. I just think that is obviously with a motion in limine, it's a technical, and for your viewers that may not understand what a motion in limine is, it is a trial motion that sort of sets the stage as to how certain evidence comes in and what the jury can consider. But I think that the probative value, if you will, would outweigh any prejudice that should come from the presentation of this evidence, which is really the standard. And I think that there's also a logical connection here. So I think the defense are going to have a hard time with this one. It would be great for the defense if they can overcome this, but I really think that the way that the rest of the evidence appears, at least at this stage, in my opinion, I think that that evidence is going to be considered by a jury.
Ryan, thank you. I think you're spot on. Let's talk about the balaclava mask. That was another purchase that Kohberger made. And we know those are common, right? I was in Dick's the other day and saw one there. I mean, they sell them at Dunham's, and people buy them. We have a drawing, though, from Dylan Mortensen, who was one of the housemates who saw the man who was tall, had an athletic build, wearing all black clothing, had the bushy eyebrows, she said. And this is the drawing she made, which looks an awful lot like the balaclava mask. So, of course, the defense wants to keep out that purchase. Franz Borghardt, how likely do you think that is?
I think the odds of Lori Daybell getting an honorary Harvard Law School degree are the same odds of this mass search or Amazon. Look, searches on the internet, searches on Amazon, it's a thing now in courts. We've tested the waters of this. These searches, strong circumstantial evidence, they're going to come in. But I want the viewers to know, though, good defense attorneys fight. And so I'm glad that they're fighting the admission of these searches. I just don't see a high probability of a judge denying it coming in. Now, good defense attorneys will have a plan B, which is, well, how do we explain searches for masks and knives, in defending this guy? And that's problematic, but it's not an impossibility. Circumstantial evidence is not the end all be all. It's only when circumstantial evidence is hitched to direct evidence that it becomes a lot more valuable. And in this case, direct evidence is an issue for the government.
Right. Franz, thank you for that. Great points. Dr. Debbie Goodman, let's pick your brain about what may have been going on in the mind of Bryan Kohberger if he did what the state of Idaho says he did. Your thoughts, please.
Thank you. Good morning. I think what was going on and still is, Julie, is the before, during, and after for individuals who decide to kill. I really think now he entered the field of criminology with the intention of learning how to commit murder and potentially how to get away with it. What's really important for me is the mens rea, the criminal state of mind, the actus reus, the criminal action. So when we're looking at a knife sheath, a knife sharpener, the balaclava, the face mask used, as we say in criminology, as the tool kit, if you will, the toolbox, what these individuals literally will bring to the crime scene, whether it's a singular item to utilize and or plural. Here, I would say clearly it's in the plural. So it really, to me, Julie, speaks to this individual's planning, preparation, and purpose to commit this heinous act against our innocent victims.
Right. Dr. Debbie, I always remember, all of us at Court TV remember the acronym you gave us a long time ago, the JAR, jealousy, anger, rage, revenge. All of those things that you believe was going on with this defendant. Your analysis has been incredible. Let's talk about something else, Dr. Debbie. So today, the two sides are expected to square off over those text messages between the surviving housemates and a 911 call that one of them made on their cell phones. How this may all factor into the time frame, of course, is key. Let's listen.
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night and she's not waking up.
Okay.
Oh, and they saw some man in their house last night.
this 911 call something else. Another issue coming in today is the question of whether one of the surviving roommates, the one we just mentioned, Dylan Mortensen, is going to be able to testify about the man that she saw. She said masked man, bushy eyebrows, tall, athletic build, and wearing all black. The question I've had really since this case began is she going to be able to make an ID? And if she can't, how damaging is that going to be for the prosecution? Dr. Debbie, let me start with you on this point. I'd like you to weigh in, please.
Sure. I don't think, Julie, that she can make a 100% positive ID. I don't think that's really her role here. I think the role is to just, with genuineness, sincerity, and honesty, explain what she saw. And what will be critical is that the individual that she saw was wearing this face mask. And here again, we have the alignment of this individual having purchased the face mask. So I think that's very important, as well as her placing the call. Giving a height description, I think that's significant as well, because if she said she saw an individual who was 5'2", 5'3", then, it might be a little more questionable. But I think in totality, what Ms. Mortensen will offer will be of importance.
Yes, well said, Dr. Debbie. An important description, maybe not an ID, as you said. That's probably doubtful that's going to happen, but a really key description. We'll leave it there for now. 11 o'clock is the time he will be in court. Grateful that you're all coming with us here on Opening Statement. Stand by, please. We're going to hit a break. When we return, talking about Cult Mom acting as her own lawyer, and our legal eagles weigh in on the many objections. Plus, murder defendant Dr. Ingolf Tuerk returns to the witness box today. It's going to happen about 30 minutes from now. He's going to be cross-examined. What was his intent at the time that he killed his wife?
She didn't wake up.
What did you then do, sir?
Lifted her up and put her on the bed.
What did you then do?
Then be comfortable, and then I tried some CPR on her.
Did that help?
It didn't work.
What happened then?
I was just sitting there and crying.
At the time that you had the glass smashed off your head, cutting you, causing you to bleed, and you came up with your hand and grabbed her with your hand by the throat, did you intend to cause her harm and kill her?
No. Oh, never.
This morning, we're shining a spotlight on the trial of Dr. Ingolf Tuerk. That was him there in the witness box. He's set to retake the stand in just a short time. Tuesday, he told the jury that he never intended to kill his wife, Kathleen. He's accused of murdering her by strangling her to death and then after the fact dumping her body in a nearby pond. The incident happening in the year 2020. And while he was on direct exam, the doctor admitted to the killing, describing the moment that he, quote, blacked out.
I snapped. I kind of blacked out.
What did you do?
I grabbed her.
Where?
On the neck.
How? Did you say anything?
Oh.
What did she do?
She just flailed around, and then she kind of flailed around and fell. We fell on the floor together, I think, because that's when I came out of my blackout. That's where we were on the floor.
What happened then?
She was not responsive. She was, passed out, and I asked her, Katie, come on, please, Katie, wake up. Please, Katie, wake up.
Yeah, and he's saying he did CPR here. I don't ever remember reading that in any of the court documents when this first came about. I said it the other day here on the show about how, well, you would think a doctor would try to save his wife. But then we know what he does is he goes and weighs her down with rocks in her pants so that she sinks in this nearby pond, eventually leading police to her body to recover it. So the question for the jury isn't whether he did this. He's telling them, yes, he did. Is it murder, though, or is it something lesser? Let's bring in criminology expert, author, and professor at St. Thomas University, Dr. Debbie Goodman. Okay, Dr. Debbie, your thoughts on this, what the doctor shared so far about snapping, blacking out, trying to resuscitate his wife. We know he doesn't call 911. And then he goes to that hotel after he dumps her body. Your thoughts, please.
My thoughts, Julie, 3 letters, LIE. I think this whole thing is a lie. I'll use the word as an acronym for some of our talking points. I think the conduct was lethal, it was impulsive, it was excessive. So even if somewhere along the way he wants to maintain that by being hit with the glass, cut with a glass, that then he would proceed in the manner in which he did with strangulation, I cannot imagine a jury anywhere on the planet agreeing that it was self-defense, lethal, impulsive, and excessive is what I think this was.
Oh, Dr. Debbie, I love that. That is some sharp analysis there. I'm taking notes. The LIE acronym. That is real. The prosecutor should do something like that in close. Let me show you a clip, Dr. Debbie, on the cross where the prosecutor's pushing back on the physical advantage that this doctor and former Olympic athlete, as you know, had over his wife, Katie.
So you'd agree that Katie was much smaller?
Yes,
She wasn't nearly as strong as you were, right?
that is correct.
And you knew that?
Yes.
You're aware of where the arteries are?
The carotid arteries?
Any arteries in the neck? You're aware of those are, where they are?
Yes.
And you're aware that if the brain isn't getting enough oxygen for any reason, death occurs?
If I'm not intoxicated, I know that, yes.
Ooh, okay, he threw intoxication in there. Dr. Debbie, what do you say, please?
Yeah, I say that's a very weak argument, Julie. And if anything, it is very important. The fact that this defendant is a credentialed medical doctor would suggest that he has a heightened level of knowledge, expertise, training, education about the fragility of life, and recognizing that within mere minutes of a lack of oxygen and lack of consciousness, there can only be one outcome, death. So once again, I'm not buying this. He knows better than most what it means to put pressure on the carotid artery, and in mere minutes, literally, it's a matter of life and death.
Yes, perhaps another lie, as you said, Dr. Debbie. Let me ask you this, please, my friend. When we think about the crime, this was horrific. This was a relationship that became very toxic, violent. There was a history of violence, as you know, between the doctor and Katie. She had a restraining order at one point. He choked her a week before they married, according to her and court documents. Then here we are with this event that's in question. Dr. Debbie, I wonder if he had accidentally killed her, in the heat of the moment, the heat of passion took over him and it happened. If he had just called 911, tried to get her to a hospital, did something other than take her body to a pond to weigh her down, I wonder if we would even be here today, if this case could have been resolved with some type of either voluntary or involuntary manslaughter plea.
I agree, Julie, 100%. Again, as a criminologist, I always look at 3 things. I look at the crime, what we'll call the before, the during, and the after. So even the relevance of what you're saying is so significant and so important. What did he do before? Allegedly, there was drinking. Allegedly, there was some type of verbal altercation, which led to physical altercation. But again, just to say I performed 911, where's the verification? Did he call 911? Did he perform CPR? We don't think so. Again, part of the lie. The during part is, okay, perhaps a jury may understand verbal leads to physical, but again, when one is using one's hands, Julie, so vicious, so violent, the release of which saves the life. And then, of course, the after. What does he do after? He takes the decedent and purposefully is now trying to conceal and weighing down with the rocks. It's all terrible, and I believe it's all pointing still to the first-degree murder.
Right, Dr. Debbie. Yeah, and it's like the cover-up, I think, is for him the worst part to try to fight back on. It's just, it looks so bad for him. It really does, no matter what he says up there. Dr. Debbie, let me ask you please about strangulation. For those of us curious, a method of killing, anything that we can glean from that in this instance or in general?
Right, Julie, as we talk about the approaches here and so many cases and so many types of death, but when we look at strangulation, and especially with the hands even, rather than a ligature, it's so purposeful, it's so intentional. The killer himself is in control and can easily release the pressure and chooses not to. And again, Julie, these crimes of exorcide, husbands killing wives, we saw it with Alex Murdaugh, we saw it with Scott Peterson, Chris Watts, and I think we're seeing it here again with defendant Tuerk.
Dr. Debbie Goodman, brilliant analysis as always. Thank you for everything this morning. We'll see you soon. Still ahead here on opening statements, we're looking at lawyer Lori's objections in her murder conspiracy trial, breaking them down with our legal eagles next.
This week,
the doomsday cult mom defending herself. We're previewing each day for you in the high-stakes conspiracy trial for Lori Vallow Daybell.
opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
What did you think when the media dubbed you the National Forest serial killer?
I think I prefer the beast of Blood Mountain.
Interview with a Killer. New season premieres Sunday at 8. Only on Court TV.
Thanks for staying with us. Now for what's tipping the scales. Lori Vallow Daybell appears to be finding out that cross-examining witnesses isn't as easy as it looks on TV.
So if I would have been hysterical, that would have been more out of character than if I was calm when everybody else was being calm. Isn't that correct?
Speculation.
Sustain.
Did he express to you that he kind of fell out of it because he hit?
Sustain.
I just didn't see it in your report, but I saw it on the body cam, so I wondered if you knew. Okay.
I'm going to object to the defendant testifying.
All right. Please only ask questions.
Sure.
When you make statements about what you saw or heard, that's testimony.
I apologize, Your Honor. Is it possible he could have been in shock?
Objection, speculation.
Sustain.
You said they got into a domestic fight consisted.
Objection.
I'm sorry.
I'm going to sustain the objection.
What was the legal objection?
Hearsay.
Hearsay.
Oh, I was just reading his report. Okay.
Then objection, no question.
Please ask your next question.
Right, but they were trying to come up to me to find out what was happening.
Objection,
Okay.
speculation, hearsay.
I'll sustain.
And that was less than a minute?
Yeah.
Objection, asked and answered.
Sustain.
Oh, just brutal, right? Rough start for lawyer Lori as she kicks off her conspiracy to commit murder trial. We're getting into day number 3 today. How are the objections going to go? Let's bring in our legal eagles and see what they think so far. Attorneys Ryan Tutera and Franz Borghardt are with us. Okay, I put together that nice little, what we call a mashup in TV to show those wonderful moments. Ryan, your reaction as you were watching that, please.
Julie, go easy on her, okay? It's her first time. Big trial. It's a homicide trial here. So hey, look, the questions were clearly objectionable questions, and she's clearly out of her element here with what she's doing. It is a dreadful performance. However, to some credit of hers, I mean, she has, I guess, the guts to do what she's doing. I don't think it's a smart move, as I said in the earlier segment, but she's doing it. Look, these questions, technically they have to be crafted a certain way that not only make logical sense to the fact finder, but also with regards to the law, conform to the rules of evidence, the rules of procedure, and the like. So you can't just fire off questions. You can't, make your questions testimonial in nature. So the prosecutor's in the right for objecting, and the judge is also in the right for sustaining those objections. I do believe that the court will probably be patient with this woman, being that she's pro se, and I think the law sort of, is a little more lax or lenient, if you will, to some degree to a pro se defendant. However, the courts are not going to allow her just to, do whatever she'd like, or to fall back on the, hey, look, I'm not a lawyer, I don't know any better. That's just not going to work. So as I said in the earlier segment, maybe now's the time to lean on standby counsel and allow them to take the reins in this very important case with very serious consequences.
Right. You're so right, Ryan. Franz, your thoughts watching that little mashup, please.
So I would probably caution the prosecutor at some point to, yes, all your objections are valid. Don't let her get into stuff that she shouldn't be able to get into. But at some point, you don't want to make her sympathetic, right? You don't want a juror or jurors to feel sorry for her because she clearly doesn't know what she's doing. So the asked and answered objection probably could have been one that she could have let slide. And that is the risk sometimes with rapid fire, absolutely appropriate objections, is you just don't want, in an effort to keep out inadmissible questions and inappropriate questions, you don't want to make the lawyer, or in this case, Lori Daybell, sympathetic. And that would be my only caution to her. But absolutely spot on, the speculation questions, that without a foundation, that officer can't testify to that. And she can't testify as a lawyer, which is ironic, though, because a good cross-examination is all about the lawyer testifying. So if she knew what she were doing, she could probably testify without testifying.
Yes, yes. Franz, I love the point you made about how they don't want to beat up on her too much, because at some point then somebody might feel sorry on that jury. So fair point there. At one point, Cult Mom did really try with an objection. Let's look back at the moment where she lodged the objection and see how it went.
Do you recall seeing any projectiles on the ground near the victim?
Objection, leading.
It's a yes or no question.
I believe I did, yes.
Oh, a swing and a miss. Ryan Tuerk, what do you think? She tried. She knew leading. She thought it was leading. What do you think?
Look, to her credit, once again, as we were prosecutors, Julian, we worked in the same office, we were taught, we're only to ask questions, what, where, when, how, all of the other questions are technically leading. So, you got to give her some credit, right? But look, as far as objecting is concerned, sometimes you're drawing more attention, to the question that's being asked by objecting. And, not every question, and as lawyers, we know this, I'm sure Franz does as well. Sometimes, when you get into this habit of objecting to everything, you may be causing the jury to, maybe place more weight on something that you're jumping up and down and objecting to. So that's the other sort of caution I would give Lori here, is that, maybe not every question, is an objectionable question. And even if it is, maybe some of the ones that are maybe a little bit immaterial, but could have an effect as to weight, you maybe let it slide, or, you maybe think twice about objecting. However, in trial, as things move fast in a trial, and you're making decisions on your feet sometimes.
Ryan, that's such an excellent point to end on, because you're so right. It's like you're ringing a bell, right, when the objection gets made, and especially with her sidebars and the jury's wondering, and when they're told to disregard, they don't really want to disregard. They want to keep kind of hanging on and finding out. All great insight. With that, would you say, Ryan?
You can't unring the bell sometimes.
Can't unring the bell.
You can't unring the bell.
You're right, my friend. Ryan Tuerk, Franz Borghardt, you guys are the best. Thank you for the brilliant analysis this morning. We'll see you again soon. And thank you at home for being with us. Come right back. We're going together to Massachusetts.